Good evening and welcome. For the first time attendees, my name is Jim Lawrence, and I have the pleasure of serving as the board chair of Fixin. On behalf of the entire Fixin San Mateo County family, we're truly honored that you chose to join us tonight. Growing up, my father often said to me, success in life comes from making every step you take in the right direction. That simple advice has stayed with me and reflects exactly why we're here tonight. Tonight's program represents another meaningful step towards our mission, and I encourage you to listen closely. Our speaker will undoubtedly share some insights and practical takeaways that can help each of us continue moving in this right direction. So thanks again for being here, and remember, teams win. Every one of you is an essential part of the Fixin San Mateo County team. Thank you. I'll turn it back to Beth. Okay.
On to you, Carl.
Thank you, Beth. Anthropologist Margaret Mead was often quoted as saying, to never doubt that a small group of thoughtful, committed citizens can change the world. Indeed, it's the only thing that ever has. It was a small group of thoughtful members of Sonoma County, and now throughout California, that have helped reshape law enforcement oversight in California, and how that work has grown into a broader statewide movement. I'll introduce a key leader helping carry that work forward later, our featured speaker, John Alden. In Sonoma County, the push for stronger law enforcement oversight didn't start inside government. It started with the community. Community Law Enforcement Accountability Now, or CLEAN, is a grassroots organization formed to advocate for transparency, accountability, and equity in policing. Its central focus has been strengthening independent civilian oversight of the Sonoma County Sheriff's Office. The unwarranted killing of 13-year-old Andy Lopez by a Sonoma County deputy sheriff in 2013 was a catalyzing event and a moment for the Sonoma County community. That event planted the seeds for what would eventually become CLEAN. CLEAN rose to prominence in 2020 as the driving force for the campaign for Measure P, a ballot initiative that fundamentally changed the landscape of oversight in Sonoma County. Measure P was approved by nearly 65% of voters, a clear public mandate for reform. Measure P significantly expanded the authority of the Independent Office of Law Enforcement Review and Outreach, known as IALERO. Most notably, it granted subpoena power, allowing independent investigators to compel testimony and access documents, tools that are essential for meaningful oversight. But passing Measure P didn't immediately take effect. There has been opposition from law enforcement and ambivalence from many elected officials, leading to much unnecessary and costly litigation. However, a recent California Court of Appeals opinion validated Measure P. Since the passage of Measure P, CLEAN has continued its advocacy, raising concerns about policies or agreements that could weaken oversight powers, meeting with the sheriff and elected officials, as well as being one of the founding county organizations of CCSO. CLEAN also collaborates with the IALERO Community Advisory Council, helping ensure that community voices remain central to accountability efforts. While Sonoma County made strides locally, similar efforts were happening across California. Advocates in different counties began to realize they were facing many of the same challenges and could benefit from working together. Some of those counties, like San Mateo, had existing organizations like tonight's host, Fixin San Mateo. That led to the creation of the California Coalition for Sheriff Oversight, or CCSO. Starting in March 2023, representatives from oversight bodies and grassroots organizations began meeting monthly to share strategies, lessons learned, and support. And I have to interject right here, if it weren't for the energy and guidance of Nancy Goodman, who brought me on board, I wouldn't be as big a part of this as I am. So I really thank her for that. What began as a small collaboration quickly grew. By June 2024, CCSO held a public launch event that drew participants from 26 of California's 58 counties, demonstrating both the need for oversight and the growing momentum behind it. Currently, the 12 official participating counties in CCSO represent 60% of California's population. CCSO is grounded in shared values, supporting effective independent oversight of sheriff's offices, promoting equity, inclusion, and community engagement, elevating the voices of directly impacted communities, and building consensus across diverse regions. The coalition continues to meet monthly and remains open to organizations and individuals committed to strengthening oversight. In many ways, CCSO represents the evolution of this movement, from local advocacy to coordinated statewide action. Now, I would like to introduce tonight's guest speaker and somebody who I'm very happy to call a good friend and somebody who has collaborated and been very successful in ensuring strong oversight in Sonoma County, John Alden. At the center of Sonoma County's oversight system today is ILRO Director John Alden. John Alden brings more than 15 years of experience in police accountability, with a career that spans multiple cities and roles. Before coming to Sonoma County, John served as Executive Director of Oakland's Community Police Review Agency, where he oversaw investigations into police misconduct and worked closely with the Police Commission on reform efforts. John spent several years in San Francisco, working within the Department of Police Accountability and the Police Department's Internal Affairs Division, giving him a rare perspective from both civilian oversight and internal systems. John has served as managing attorney of the Independent Investigations Bureau in the San Francisco District Attorney's Office, as a prosecutor in Sonoma and Marin counties, and served as an Unruh Fellow in the California State Legislature. Today, as Director of ILRO, John oversees independent review of the Sheriff's Office, including both patrol and jail operations, helping ensure that accountability systems function effectively and transparently. And I will add to this that having worked closely with John in the 3 years that I've been with Clean and seeing his level of professionalism, his success is recently borne out by the Court of Appeals, is really it's awe-inspiring. Having worked in San Francisco, not with John, but knowing the systems that he was in, it's not easy to do. So I think we are all should be very honored and happy to have John Alden with us tonight. And with that, I give you John Alden.
Oh, thanks, Carl. That was really sweet. I like that a lot. You're very generous with your introductions. So yeah, my name's John, and I'm currently the Director of ILRO in Sonoma County, which many of us have believed for some time, and the Court of Appeal has now confirmed is an Inspector General's office under AB 1185. So I thought tonight I might talk a little bit about the origin of our model, how it's changed over time, and some of the things that we do. And Nancy, Carl, whoever else, please let me know if there's some other topics you'd like me to cover or switch gears to your questions you'd like to ask, midstream. Please feel free to interrupt. As you were hearing earlier, the system that we have in Sonoma County started really in 2016 after the shooting death of Andy Lopez in 2013. And it came from community demand that there be some kind of an auditor model in Sonoma County. So in the first few years of the model, ILRO would accept complaints from the public about alleged misconduct by sheriff's deputies, pass it over to the Sheriff's Office Internal Affairs Division to investigate. So they would actually talk to people, pull evidence, look at documents, look at videos. They would come to a conclusion, and they would share that conclusion back to ILRO to review. ILRO did not have the ability to change the outcome on any of those cases, but could give advice back to the Sheriff's Office about how maybe those cases could have been done better or about why the results should have been different. So it was a purely advisory model, which is part of why it was called an auditor model. In 2020, the community came forward and passed Measure P, which expanded the role of ILRO in a few ways, but the ones I think are probably most important for this conversation are that it layered on some independent investigations in addition to the audits that ILRO was already doing. In our case, in Measure P, those independent investigations that ILRO became empowered to do were only in very limited circumstances. Generally speaking, they were situations in which some conduct in the sheriff's office led to or was, part of an incident in which someone died. So that might be things like a sheriff's deputy hitting someone with a car who then died, or a sheriff's deputy shooting someone who then died, or someone dying in the jail or in a patrol car when they're in their custody of the sheriff's office. And there could be other examples too, but those are the ones we see the most often. And then there was also a provision that said that we could directly investigate any case that we thought had not been adequately investigated by the sheriff's office. And then third, cases that involved claims from whistleblowers inside the sheriff's office who wanted to allege some kind of misconduct internally and have that investigated by someone other than the sheriff's office. Because obviously, if they worked in the sheriff's office, they'd be concerned about retribution, or maybe concerned that no one would look closely at the allegation. So, pardon me, still getting over a cold. So with these three different independent investigation categories coming online after Measure P passed in 2020, Measure P also included in there subpoena power in order to make sure that ILARO could actually effectively investigate those cases. So with that subpoena power, we're able to subpoena documents and subpoena people to come talk to us. I'll tell you a little bit more about how that's working out on a practical level, but that was the idea in 2020 with Measure P. At roughly the same time as Measure P, the state legislature passed AB 1185, which was then signed into law and became effective in January of 2021. And that law creates inspectors general in California. More specifically, it gives the option to every county to create an inspector general that would then have the ability to issue subpoenas and conduct oversight over sheriff's offices. Prior to AB 1185 passing, there was no explicit grant of authority to counties to create any kind of oversight system for sheriffs. And prior to AB 1185, many sheriffs argued that it wasn't even legal in California to create some kind of oversight over a sheriff because they just simply could say, hey, look, there's nothing in California law that allows for that. And they would point to a California constitutional provision and then a part of the government code that describes sheriffs as being independent from the Board of Supervisors in their individual county. So prior to 2020, when AB 1185 passed, it wasn't really clear what model we could use to do oversight of sheriff's offices. In that regard, Sonoma County was groundbreaking and maybe even an uncertain legal foundation because there wasn't a grant of authority to counties to create systems like that. So today in 2026, the one and only mechanism that exists in California is the creation of an inspector general to oversee a sheriff's office. There just is no other grant of authority for any other kind of model, for better or for worse. Now, California law doesn't tell us very much about inspectors general or what they're supposed to do or why even that name was picked necessarily. But it probably comes from the fact that around the same time that ILARO was founded in 2016, Los Angeles County was having a similar challenge. Their challenges came in part from sheriffs who were themselves prosecuted for crimes committed in office and also from the conditions in the LA County jail system. And that inspector general, that oversight system in Los Angeles was called an inspector general from the very beginning back in 2016. So that might be part of the reason why inspector general is one of the terms that state law now uses. So now that ILARO is an inspector general and has the subpoena power and has the ability to investigate, we really have two tracks for our work. The audit track, which we still do, and the investigative track. And I want to explain briefly how those two are different because the work we do is quite different in those two. So in the audit track, we're really only auditing the results of investigations into specific complaints. There are other kinds of issues that can be audited. For example, in the Los Angeles County model, we see that inspector general often doing performance audits of a particular, say, operation or part of the sheriff's office to see if across the board that whole unit is performing to expectations. Doesn't have anything to do with a complaint. They're just independently looking at the performance of that unit. We don't have that yet in Sonoma County. It's not to say we couldn't have that, but the public demand has been to investigate have individual complaints investigated and then audited by ILARO. So what does that look like? Well, In our system in Sonoma County right now, a person who has a complaint about the sheriff's office can show up at ILRO or email us or give us a ring by phone or fill out a form online. In any event, they can contact us directly at ILRO and express their complaint. We'll do our best to work with them if they're willing to talk to us about what the complaint is, to try to give it some more detail, make it clearer to the folks at the sheriff's office who will eventually investigate it, what it is exactly this person is complaining about. If it becomes clear that the things they're telling us about aren't actually a complaint or are about some other agency altogether, say is really about one of the police agencies in our county, like the Santa Rosa Police Department or the Petaluma Police Department, we'll refer them over to those other agencies instead. So in our case, we only take complaints about the sheriff's office, and we do a little bit of triage with each complaint to make sure it really is truly a complaint and it's really about the sheriff's office as best we can. And then we send that over to the sheriff's office. Their internal affairs division, which they currently call professional standards, is staffed with some sergeants and a lieutenant who supervises them. And that lieutenant will then assign to one of those sergeants the work of investigating that case. Some of the simpler cases, they might get in touch with a sergeant who supervises the deputy that was involved in the incident in the first place, and have that person, the direct supervisor, investigate the case. Say something like discourtesy or failure to write an incident report, something that's pretty straightforward. So they also have this ability to get help from other sergeants out their parts of the sheriff's office. They'll have the assigned sergeant interview people, pull materials, review video, do all the work that an investigator would do, memorialize all of that, save that material, and then write a report about it. The sheriff himself will figure out what to do with the case, like impose discipline or ask someone to be retrained or realize one of their policies needs to be improved. And then they'll send all of that material back to ILRO so we can look at the report, all of the investigative steps that were taken and the material in the investigation. As auditors, we can't trump or overrule that investigation, but we can provide feedback to the sheriff's office, which we eventually share back to the public as well, the complainant, about what we think could have been done better, if anything. Oftentimes, we agree with the sheriff's office conclusion in the case. Sometimes we don't, in which case we'll let them know. We also check to make sure the case was investigated completely and thoroughly, and that it was done in a timely way, and we have very specific metrics for those. Timely, for example, means that a case has to have met 4 specific deadlines that we've agreed with the sheriff's office should apply to every case. Completeness is a question of meeting roughly 20 items on a checklist that we've created in collaboration with the sheriff's office. So we'll assess for completeness, we'll assess for timeliness, and then we'll give the sheriff feedback about whether we agree or disagree with the case conclusions. And then the sheriff might change his opinion. When I first came here, it was rare that the sheriff would change his opinion about any given case. More recently, the sheriff will change his opinion from time to time about given cases, and I think that's led to some significant improvements in the sheriff's office. One of which is significant improvement with the way the canine unit works. So in that unit, sheriff's deputies use dogs to find people, to sometimes detain people or bite people. And we concluded off a series of audits a few years ago that the way that that unit had been trained was training them to use the wrong legal standard for when it was time to use a dog to bite someone. And as a result, they were getting sued and having to pay out significant sums of money. So we proactively pointed out that pattern and said to the sheriff's office, here's how the policy can and should be better. And the sheriff didn't adopt all of our recommendations, but he adopted many of them, altered some of the policy and some of the training for the canine unit. And since then, we haven't been seeing these very expensive claims from the canine unit. They've been using the dogs more appropriately. So I think that's an example of how we can proactively use that audit process to improve the performance of the sheriff's office. So I had these 2 tracks I mentioned, the audit track and the investigative track. So with the investigative track, we have far fewer cases that we might investigate, because really we're only dealing with the most extreme of cases, deputy-involved shootings, deaths in custody, and the like. We have completed only a handful of direct investigations in Sonoma County so far, and there are a couple reasons for that. One is, again, they're not very common. But another is that while we have had pretty good compliance from the sheriff's office when we've subpoenaed records and documents and videos, in custody deaths and deputy-involved shootings. We have not had success in getting the sheriff's office to comply with our subpoenas for those same materials in whistleblower cases. And as a result of that, about 2 years ago, we issued some subpoenas and a very long subpoena in a whistleblower case. The sheriff refused to comply with the subpoena, wouldn't provide us any material, and so we had to go to court to enforce the subpoena. One thing I think maybe some decision makers don't always understand is that subpoenas necessarily mean that the way you enforce them is to go to court. There is no other enforcement mechanism for a subpoena. And in fact, it is ultimately only a judge that can enforce a subpoena, not anybody else. So the subpoena process is really a legal permission, if you will, to go to a judge and get the judge to order someone to comply. So when we gave our subpoena to the sheriff and he refused to comply with it in this whistleblower case, we were able to go to court in Sonoma County to seek compliance. To the best of my knowledge, that's the first time that any inspector general in the state of California has taken a sheriff to court to comply with a subpoena. And in our case, we initially got a result from the trial court that was frankly kind of confusing, in which the trial court said it couldn't figure out if we were an inspector general or not, and so then didn't make a decision. So we appealed that case to the First Appellate District, which was one of the appellate courts here in the state of California. This one's located in San Francisco and covers roughly most of Northern California. And that court just came out with a decision last week that explains their thinking about these kinds of subpoenas. And so they clarified a few things for us. One is that Ayalera was, in fact, an inspector general. For us locally, that's important. For people elsewhere who are creating inspectors general, you probably won't have that problem. But make sure your enabling ordinance says you're creating an inspector general, not something else. And then second, it clarified that every inspector general has the power of the subpoena, that those are indivisible. They come together. That's how state law designed that system. They can't be split apart. You can't have an inspector general without subpoenas. And there doesn't appear to be any other authority for creating a subpoena power other than creating an inspector general. So if you want oversight that really can get to the materials it needs to see, you have to create an inspector general. Pardon me. If you create an inspector general, it necessarily has a subpoena power every time. You can't create one without it. Also, they concluded that that subpoena power reaches to all the documents and people inside of a sheriff's office, and that therefore our sheriff had to comply with that subpoena. Now, there are some other pieces in that case that were important to us locally that probably aren't important to people in other places, but might be somewhat illustrative. Like one of them was that a collective bargaining agreement or an MOU or other agreement with a union can't trump the subpoena power that we just described, right? So once it's created, it just is. It can't be limited or altered in the negotiation process with unions. That'll be important, I think, for other agencies as they're being stood up in the future. And in our case, the court also ruled, but didn't want to make part of its published opinion that our subpoena power also reaches individually to the sheriff himself, not just all the people that work for the sheriff. For us, that was important because the sheriff was arguing that any subpoena that was ultimately looking into his conduct would be void. And so we were glad we won that. But since the court didn't flag that part of the decision for publication, making part of their permanent opinion for other people to read, that's not necessarily going to be binding on other people. I suspect other courts would conclude the same, but for whatever reason, the court didn't include that in the final decision. So that decision now gives us a foundation on which we can move forward in a much more robust way on these subpoenas and whistleblower cases and other direct investigations in the way that the voters intended us to do. So, I'm looking forward to being able to execute on that power now that the court's given it back to us. The other problem we're having with subpoenas is what happens when we subpoena a sheriff's deputy to talk to us as opposed to give us records? And that deputy then claims their Fifth Amendment right to remain silent when they talk to us. This has become a problem for us because that actually happened in a case we investigated last year. It was a shooting death, and the deputies involved were willing to talk to investigators who were trying to figure out if those deputies had committed a crime. They were willing to talk in a civil deposition, but when it came to talking to us, long after those other two processes were already done, they claimed the Fifth Amendment right to remain silent. So you might wonder, well, was that in good faith or not? Probably not. But that said, the courts don't allow us to test whether that Fifth Amendment right is really a good faith invocation of the Fifth Amendment right. It just is a right, and there is no way to test to see what the intention behind it was. So once they claimed the Fifth, we weren't able to ask them any more questions. This is very common in public employment, not just with police, but also with firefighters, teachers, and a number of other folks who work for government. And the way the situation is ordinarily resolved comes from a U.S. Supreme Court case called Garrity from 1967, in which the U.S. Supreme Court said, well, the resolution for that is that once a person who's a state employee asserts their Fifth Amendment right when they're being interviewed by their employer, the employer can tell them, okay, that's great. If you don't talk, we're going to fire you. But because we're giving you that order to either talk or be fired, statements you make cannot be used against you criminally. They're immunized. It's the technical term. And that process has been around for almost 60 years now in the US. And it's very, very, very common that people in public employment, particularly police officers and deputy sheriffs, are given these Garrity orders. In California, there's another follow-on case called Liebarger that reinforces how this is done in California. And yeah, it's done all over the place. In my experience, I've never seen someone in law enforcement in California refuse to make a Garrity or Liebarger order in a situation like this, but our sheriff refused. So now we are trying to figure out as far as I know, first in California situation. What do we do when the sheriff just won't make that order? Our local enabling ordinance, Measure P, seems to require, to me, as far as I can tell, the sheriff to make those orders. It talks about the sheriff's obligation to ensure full cooperation of all the members of the sheriff's office. But now that he's declared he's not going to do that, and he's been very public about it, it's not really clear what the solution is. It certainly is the case that if he wants to start making those orders, we do have to go through what California calls a meet and confer process with the unions in his agency to talk about some details like how would they know that they've been ordered? What does the order look like? Who gives the order? Some details like that are fair game to ask questions about in this meet and confer process between union and management. But ultimately, it's not something that a union can block using meet and confer. It's just a management decision of the employer. But if your sheriff won't do it, sheriff won't do it, and there's no one else to force him to do it. So I mentioned this in part because I think next year there's going to be an opportunity to fix that problem at state law. In New Jersey, they fixed this problem by saying that as a matter of state law, all public employees must talk when questioned by their employer, and if they assert the Fifth, they must answer or be ineligible to hold public office any longer. And as a result of that, they're held immunized for those statements. In other words, it takes that case-by-case order and makes it into a state law that applies to everybody across the board. I could see California creating such a law for sheriffs and sheriff's deputies. Since we know that already worked in New Jersey and has for decades, I don't see why California wouldn't do the same, since we have sheriffs who now indicate they won't make those orders. So, or at least one sheriff that says they won't make that order. So I think you should probably look next year to seeing if there's a bill around that. And if so, we could really use your support with that legislation, because without that, it may be that our subpoena power for all the inspectors general in California won't effectively allow us to get to interviews with deputies without that backup. I've had a lot to say, and you've been very patient in listening to me, and I appreciate everyone nodding along as I'm talking. It makes me feel like you're actually hearing me. That's good. And I would be happy to answer some questions or talk about other topics that you might want to address.
Thank you. Thank you so much, John. Lots of really good information, and we have some great questions. And I'll start with, have you known or do you know any law enforcement groups or organizations that actually actively do support a form of oversight? Or is that just
Oh, that's a great question. I mean, I certainly have seen individuals, say, chiefs of police who have been very supportive of oversight systems. And on occasion, I've even seen police unions endorse ballot measures that supported various kinds of oversight. Like when I was working in Oakland, there was a measure, oh gosh, had it been Measure S, if I remember right, that was going to alter some of the ways that the civilian oversight system worked, and the local police union supported it. So, here and there, I've seen that. I am not aware of a large policing organization that's affirmatively said they're in support of oversight, but if any of you know of one, I'd love to meet them.
Okay, very good. Thank you. And so, in the areas where you've gotten information from the sheriff's office, do you feel like it has made a difference in how the sheriff office works, made a difference to the relationship with the community, both, neither?
Yeah, well, that example I gave about the canine cases, I think, is an important one. Now that was again a case that came. Well, you know what? Let me back up a little bit. One thing that's really important, I think, about that situation was that we were auditing these investigations that the sheriff's office completed. But the reason we were auditing them was not that someone had made a complaint about them, but because there was a requirement inside the sheriff's office that they do their own investigation into any use of force that resulted in a significant injury. And then there was also a requirement in our enabling ordinance that we at ILRO would audit those investigations. So absent any complaint, we still were looking at all three of those cases and digging into them to see what was going on there. I mentioned that there's no complaint because it has been my experience that some of the biggest changes we've been able to make in policing did not come from public complaints. It's not a knock on public complaints. It's just that there is not necessarily a correlation between the things people complain about and the instances where some specific thing happened that we're able to use as a catalyst to create positive change. There are a lot of reasons for that. I mean, one is a lot of people don't know what's going on behind the scenes when something happens to them with the police. They might not be aware that what happened to them was a violation of policy, and they might not complain about it. They might not be aware that what happened to them was consistent with local policy, but that policy wasn't compliant with law. There's so much that an average member of the public doesn't know when they're making a complaint that they're just not, unfortunately, well enough empowered with the knowledge to know which instances are the ones that really need some digging to make sure they don't happen to someone else in the future.
Okay.
I think most complainants, try to assess that issue from a good faith position of trying to make sure what happened to them doesn't happen to someone else.
Right.
But that doesn't mean they necessarily know where those opportunities are. And so I think being able to proactively audit issues that aren't from complaints is often one of the most powerful ways to make change. And that's one of the things I like about the Inspector General model is that while state law doesn't say that Inspector Generals can only audit complaints or can only do independent investigations, it creates this model in which at least there's an Inspector General, which presumes some staff and a subpoena power. So those inspectors general could look into any number of issues depending on how you structure them at the local level in your county. And if you give them the ability to proactively look for issues where there's some significant cost to the county or there's significant injuries, that can be really powerful. In Sonoma County, our audit stream contains not just complainants, but also cases that got a lot of public attention. And also cases where there was some kind of a civil settlement, or there was a civil claim made that, we got sued, we, the county, got sued in some way. And a lot of those kinds of cases, can yield really substantial benefits in terms of improving policy.
Okay, great. Thank you. Speaking of inspector generals, do you have any thoughts about if an inspector general in county with Chad Bianco, if an inspector
Yeah.
general could have done anything about him taking the overreach and seizing the election ballots recently?
Well, I doubt that Inspector General could have stopped him. Even
Okay.
our Attorney General at the state level seems to be having difficulty doing that. But certainly an Inspector General could shed a lot of light on that and get out to the public how that instance is really aberrational, what some of the negatives are going to be of that decision,
Okay.
what the justification for that warrant was, if any. I've heard some media reports that describe a little bit of information about how Sheriff Bianco got that warrant, but I'd love there to be a fuller, deeper dive with people who have some expertise in the field that could really get those facts out to the public so we could all assess a little bit better whether the warrant was justified.
Thank you. Okay. And so you mentioned timeliness, that part of what ILRO looks at is timeliness. Are there any standards for incidents, like in deputy-involved shootings, that gives the public a timeline that they could expect, or particularly for directly impacted next of kin, when they should be notified, when they meet with law enforcement, an initial ID of officers or deputies involved, what the status of the investigation is? Is there any standard currently?
Not a lot.
Okay.
Honestly, no. And usually most of those steps take vastly longer than most people in the public are comfortable with.
Yeah.
There are a couple that do apply. There is a state statute that generally gives law enforcement a year to conclude their internal personnel investigation of any kind of misconduct that they discover. It's a year for when they found out about the event. So with things like deputy-involved shootings or officer-involved shootings, that usually starts immediately because everybody knows about it almost from the instant it happens. But there are a slew of exceptions to that 1 year limit.
Okay.
One of them is if there's a criminal investigation of the officer, which almost always happens in those kinds of cases.
Okay.
Then the 1 year doesn't even start to run, the timer doesn't start on it until that criminal investigation is done. And those can take a year or two. So often it's 3 years out that the administrative investigation is done. If the person who was harmed by law enforcement or their family sues, the administrative case can be delayed until after that lawsuit is done. And those lawsuits can take 5, 6, 7 years sometimes. And then the administrative investigation might not be done until that lawsuit's over.
Okay.
So it can be a very, very long time. As for when people are notified about the names of the officers, the California Supreme Court, last I checked, had a general principle that it ought to be within 10 days. And then there were some exceptions to that to get a little bit more time, but not a lot.
Okay. Okay. So here in San Mateo County, I don't know if you're aware, but there's some hesitancy in terms of appointing an inspector general. And recently, the sheriff has mentioned maybe having an ombudsman as opposed to an inspector general. Where we don't know if this would sit inside of the sheriff's office or outside, and if it would be for the community in general or just maybe in the jail. Do you have any thoughts about the strength or the weakness of such a model using an ombudsman versus the inspector general?
Well, I'd start with saying that in California, there is no authorization for an ombudsman. So none of us really know what the legal framework is for doing that. Whereas there is a legal framework for an inspector general. So one concept to keep in mind is inspector general has an enabling statute at state law and a very specific role and specific powers. Ombudsman is not known, right? So one would be pioneering solo what that is without a state law justification for creating one. So it'd be a lot less clear how that would work.
Okay.
In other systems, the second thing I'd say is in other systems where we see an ombudsperson, they're usually someone that is there to resolve disputes or mediate disputes. That would suggest to me that if one is going to call it an ombudsperson, that they're probably not doing any kind of independent investigations or audits. They're just mediating disputes between complainants and the sheriff's office.
Okay.
I don't know if that's the vision in San Mateo County, but that's what the name suggests to me. And if that's the case, that's a very limited role. That's not going to create any of the systemic change I was talking about earlier that we've seen in Sonoma County. But there is some value in having a mediation or ombuds program in, between complainants and the law enforcement agency. And I do think that in and of itself is a good thing, but it is not going to help you detect any wrongdoing. It's not going to help you figure out how to systemically change some of the policies. It's not going to help reduce your civil liability down the pike. It's not going to be a check to show that policy is compliant with law and it's not going to root out any wrongdoing inside of a sheriff's office. So
Okay.
it's not going to help with the Christina Corpus problem.
Okay, great. Thank you. Thank you. How do you communicate within the community about how they can use your oversight services?
We try to use as many modes of communicating as possible. So I don't know that we necessarily have this worked out perfectly, but we do have a website. We have a Spanish language website, and I'm going to flag here that we don't use Google Translate to translate our website. And there's a little globe at the top on a lot of websites. You click it, and Google kind of goes through and translates your material. I speak Spanish, and when I read the Spanish translations of our website using Google Translate, they're unintelligible and
Oh my
sometimes they're just
goodness.
wrong. So
Okay.
very technical information like that, I think it
Mhm.
pays to have your own Spanish language website. We do, in addition to the website, we keep on there videos of meetings. We end minutes. We try to put as much material as we can on the website to be accessible to people. Annual reports, policies, our enabling ordinance, etc. We also do an electronic newsletter, which we send out by email. It posts to Facebook and also to Instagram. Some people really like, Twitter, now called X. Personally, I don't, but a lot of people do like that one. So figuring out what social media platforms to be on, I think, is also important. And again, in multiple languages, I think is wise.
Okay.
For a while, we tried some radio ads in Spanish, and I think that helped a little bit, but it was very expensive. And we also go out into the public, both to public events where we might be able to table and talk to people, but also talking to different organizations. We'll show up at a meeting of a Rotary
Right.
or of a neighborhood advocacy group, right? And talk to people about our services, what we do, and how it works, just so people have a better understanding of how to make complaints to us.
Okay. That's great. Thank you.
Mhm.
You mentioned about cost to the county. Do you think an IG could be used to advise a county board on what policy choices within the sheriff's office might make the county vulnerable or even less vulnerable to lawsuits?
Yeah, absolutely. In our case at ILRO, we're able to make recommendations about policy changes as they show up in the audit stream that they're working on. And our theory in Sonoma County has been that audit stream, now that we're putting complaints in there and civil claims in there and cases that got a lot of public attention in there, would probably hit most of the instances where some change can be made. And we're finding that that is actually the case. Like that canine example I gave you, I think is a strong example of how it can reduce overall civil liability for the county. Um, I also think that auditing civil claims made against the county is a powerful way to figure out how to reduce civil liability. If, after all, those are the cases that we're paying money out on, I think it pays, if you will, to take a close look at those and see what you can learn from them. It has been my experience that in most counties, there is no substantial analysis done of those kinds of cases. And I can understand why no one has the time, but having an inspector general who can do that, I think could really improve the county's bottom line. And I think we've seen that in Sonoma County.
Okay. Okay. Several counties have tried to set up oversight policies and, of course, been met with resistance from the sheriff unions, other law enforcement agencies. And, the meet and confer process can take more than a year. Do you have any thoughts on how to work within that framework?
That's a great question. I mean, whether one agrees or disagrees with the way the meet and confer process in California has been set up in this environment, there's really no question that meet and confer is a required process.
Right.
So, theoretically, one could go to the legislature and try to change that process. But setting that aside for a minute, without that kind of relief, all of us need to learn how to do this meet and confer process. I think it's important in the meet and confer process to have someone at the table on the employer's side, on the county's side, that understands oversight. When I see these meet and confer processes done when there's no one on that side of the table who has some oversight experience and understands how these processes work, then sometimes you get some really odd agreements back. You got to keep in mind the folks over on the other side of the table, on the union side of the table, they know a lot about oversight and they know a lot about discipline and they know a lot about where records are kept and they know a lot about how policies are made and they already have some strong opinions about which ones they don't want to see changed. And so they're going to be much more effective negotiators in that process than are the people on the county side who often really don't know very much about that, especially
Right.
with sheriff's offices where much of the work of the sheriff's office is done inside the sheriff's office, not at county council or at human resources or in some other agency inside the county, like you might expect with a different agency. So I think it's really important to have someone who knows that material, who's inside the room during the entirety of the meet and confer process. And that's perfectly legal to do, but it's, I think, really important for us in oversight to insist that it be done that way.
Okay. That's a great point. Thank you.
Mhm.
How is the staff for ILRO chosen?
When we were originally formed, one theory we had was that if the auditors were attorneys, it would be easier to argue that they should have access to all the material that we're looking at. One of the things we got out of this appellate district opinion was clarity that you don't necessarily have to be an attorney to look at this material, but you do have to be an inspector general. That's another, I think, important point here is that between state law and the decision we just got from the appellate district, we know that inspectors general can look at discipline cases of sheriff's deputies. It's not clear that an ombudsman has that legal ability or that anyone else does.
Okay.
So anyway, back in 2016, we thought maybe it would have been easier if the auditors were all attorneys and could do that. I don't think that's necessary now, but I will say an advantage of us having a number of attorneys as auditors is that they're extremely well qualified to do the work right out of the gate. But then in addition to that, if we need to enforce subpoenas, they can go to court to do it themselves. We don't have to have county counsel do it for us.
Okay. That's great.
Mhm.
What is the attitude of the county supervisors and the sheriff towards ILRO and civilian oversight in general? And to what extent are the supervisors helpful to the oversight process?
That's a great question.
It is.
And, I think historically it's varied, supervisor to supervisor, right? Like,
Yeah.
um, every supervisor has their own political pressures and a different perception of who their constituents are, and probably different people that help them get elected. And generally, I'm not aware of any exceptions, but as far as I know, all the supervisors in California are elected by district within their county,
Yeah.
right? So they each have a different geographical area that might have different concerns. And if they're elected from an area that's really rural and has no police departments, the demands of their constituents are going to be really different from the supervisors who say, come from a district that's very incorporated, where it's just towns and people there don't really rely on the sheriff or law enforcement services on a day-to-day basis. And maybe only have a foggy idea that the sheriff is responsible for maintaining the jail and everything that happens there.
Yes.
So, I would say that that varies a lot from individual to individual. And we certainly have had, supervisors who were very clear and very public with their feeling that it was not necessary to have an organization like ILRO, and others who have said that it's really actually essential to have an organization like ILRO, and some who are in the middle.
Okay. Great. And one final question for us here in San Mateo County. What are a couple pieces of advice you could give us on how to best get an inspector general in San Mateo County with the level of resistance we are meeting in doing so?
Well, I think I might point out that one of the things we've learned from this appellate decision is that if you have a stood up inspector general that's there all the time, as opposed to on call, you can create a system for bringing in whistleblower complaints, have the inspector general issue subpoenas to investigate them, and then get answers to your questions. And that process, when it's there all the time, as the first appellate district just said we can do, is, I think, much more likely to catch problems at an earlier stage than if you wait for a large number of complaints and then have to farm them out to somebody who doesn't know the system, is from out of town, hasn't had opportunity to learn your local sheriff's office. That's not in any way a critique of the report you got from Judge Cordell, but I do think it is much more difficult for somebody to just sort of airdrop in, if you will, parachute in, have a whole bunch of complaints, not know any of the players or the systems or the institutions, and try to figure all that out. And if you have an inspector general who's been there for a while, you'll be able to better develop an understanding of the agency so that it can be more effective when those complaints come in and catch them earlier. And then, second, I'd also say, Like, why wait for something as traumatic as all the complaints about Sheriff Corpus to come down to have someone taking a close look at your sheriff's office? It's way too late at that point.
Right.
If you have an inspector general that's proactively double checking things inside the sheriff's office, you're much more likely to figure out the problems at an early stage. When they can be corrected, promptly and inexpensively, and without a great deal of public drama like you had with the Corpus issue.
Yes. Wonderful. Well, John, thank you so very much for being here with us this evening. A lot of great information and appreciate your expertise and your willingness to share it with those of us here tonight. Thank you so much.
Thank you for having me. It was a real pleasure to chat
Absolutely.
with you all.
Thank you. Thank you. Okay, so I have a couple of announcements, a couple of calls to action. And one is, of course, our monthly happy hour, no RSVP required. Come join us on Tuesday, April 21st at Das Beer House in Redwood City. We look forward to having you join us to just come and talk and spend time together and enjoy each other's company. And then secondly, we have the ICAC meeting on Wednesday, May 6th, 6:30 to 8:30, downtown Redwood City. It is a hybrid meeting, so it's also available online. If you can come in person, that's fantastic. But if not, you are welcome to join online and would love to see you all there as well. Thank you. And I'll turn it over to Nancy.
Hey, thank you, Trina, and especially thank you, Carl, for all your work that you've done in Sonoma County and with CCSO, and John for those amazing insights. This was really powerful, and we will share it with members of our ICAC. I'm Nancy Goodman, the Executive Director of Fixin. We're all volunteers that you see today. We got started, I just wanted to share with people who are new, 5 years ago in May, with the mission of establishing independent civilian oversight of the Sheriff's Office to make transparency, accountability, and fairness for everyone in the community real. We were endorsed by 6 cities and towns locally, representing more than a third of the county, as well as 35, local groups and faith organizations and political clubs. And we are together the Coalition for a Safer San Mateo County. After a couple of years of hard advocacy, our Board of Supervisors in 2023 did create the ICAC, the Independent Civilian Advisory Commission on the Sheriff's Office. They were clear that this was not oversight, it was advisory, but they said they could come back and amend it later. They just wanted to take a first step. So all told, it was a victory of oversight and truly is a historic first step, and it wouldn't have happened if we hadn't pushed for 2 years. But they did not set up an inspector general. They said they would create a panel of experts who could be called on ad hoc if needed. And that's how they got Judge Cordell to look at the allegations about Christina Corpus and her chief of staff. We don't think that worked well. It generated 10 or 15 lawsuits. I've kept track, but lost track. I write them down. 50 million or so claims against the county for mismanagement, misconduct, retaliation, etc. Those are not all going to get settled in the plaintiff's favor, but it's a liability for the county. In April 2025, ICAC recommended that the board establish a permanent, regular, ongoing inspector general instead of having an ad hoc person to do things that we're talking about, like looking at deaths in the jail, looking at incidents or allegations of excessive use of force, and to take complaints. It would be a safety net a safety valve, for the deputies who had no one to really turn to when they were having a toxic work environment due to their top command sheriff, because the sheriff has no oversight. So really, the Board of Supervisors, our board, does not yet support a regular ongoing inspector general. So we have our work cut out for us. And in fact, as one of the questioners mentioned, the new sheriff, who's great, and we work well with him and his staff, has suggested basically putting in an ombudsperson, possibly within the jail, within the sheriff's office, possibly within the county, to look mostly at complaints about the sheriff. But as I think John pointed out so well, that wouldn't be proactive. It would wait till there's a complaint, and it would be limited to just looking about complaints in the jail. And importantly, they would really mediate between the two parties and try to resolve the problem without looking at patterns and data and trends. So our job, I think, as a community is to make clear the importance and the difference between an inspector general and something else, and try to get the board support. And it's through education as well as advocacy. And so we really appreciate your coming today and everything that you all are doing in your various counties. We have so many members from CCSO, from Los Angeles, San Bernardino, Riverside. I've lost track of the other counties. So thank you so much. And thank you all for coming. We'll see you next month, or we'll see you at happy hour.
Yeah. Thank you. Bye-bye.
Bye, everyone.